Registrar of the Supreme Court, journalists, counsels, and every guest present this morning. In the early hours of the 14th February 1972, the South Block of the Reef Hotel was severely damaged by an explosion. And immediately after the incident, it became obvious that it was a politically motivated incident. The accused was tried, convicted, and sentenced to undergo 12 years in prison. Because of the political connection, allegations of the making of bombs, and a prominent politician as a witness, the media published the record of proceedings of this trial in full. There was a reason to do so. It will be difficult for me to state the exact reason, but a few months or a year before, a person was accused of more or less a similar incident, and he was acquitted by the court. And at the end of this session, it will be obvious to us as to why, at the time, in 1972 or 73, the journalist decided to publish the transcript of the proceedings of the court. Not all of us appreciate the role of the media in the administration of justice. The Honorable Chief Justice this morning has said that we need to bridge the gap that exists between the media and the courts. Unfortunately, when there was the design of this new building, there was no press gallery that in fact Merkley came up with the famous quote that the gallery where the reporters sit has become the fourth estate of the realm. We have to acknowledge that reporting of cases is crucial in a democratic society. I would say it is necessary in a democratic society. It has been said time and time again that every person has the right to be tried to a public trial, a fair public trial, by an impartial and independent court. And it is the media that to a large extent ensures that such trials are conducted in this manner. The judges performs the very lonely function of preparing the judgment after having heard the evidence. But the judge has to exercise the role in a judicious manner. And the press has to ensure that it acts as a check, as a watchdog on the exercise of not, I would say, the judicial function, but also the prosecutorial function of the Attorney General in this case in the country. It is obvious that this workshop And as I said, the Chief Justice has already set the tone that it is to bridge this gap. It is not just to expose you to the workings or the administration of justice, but to a large extent, to indirectly lobby the press, lobby the media, to be more active in the reporting of court cases. However, the media should not. There are restrictions, and these restrictions or restraints has to be exercised with caution by the media, so as not to allow cases to be tried by the media, where verdicts are given before the court decides on it or passes it. So, often also, litigants find themselves faced with their hearings being public. And to a lot of them, they feel that it is somewhat an invasion of their own privacy, so that their personal matters are being openly tried before the courts. But we have to acknowledge that a public hearing protects against bias and ensures, as has already been said, judicial independence and impartiality. The judges, the prosecutors, the witnesses, the defense counsels are all under the eyes of the citizen through the media. The publicity given by the media to the court cases, in particular to the prominent ones, put obvious pressure on the machinery of justice. And such pressure whatever pressure that is put on the witnesses, the judges, the prosecutor, or the defense, however we view it, or we judge it, or if we are grieved by it, is the right pressure. So it is a pressure for us to do what is right, so that the prosecutor, in the prosecution of the case, acts as the minister for justice. The witnesses give truthful and accurate evidence, and the judge, the defense, will defend its client to the best of his ability or her ability, and the judge will judge fairly, and if the accused is convicted, he will then pass the appropriate sentence. I do acknowledge that the Attorney General has a remarkable power in respect of criminal prosecution. The Attorney General exercises a power that touches the liberty and lives of a great number of the citizens, and also their family. And by exercise of such power, the prosecutorial role of the Attorney General is often under the scrutiny by the media. Such scrutiny is important because it discourages capricious decisions or oppressive prosecutions, what often the lawyers will say persecution. So it is important, therefore, that the role of the media is promoted. And for the Attorney General, the media acts to a large extent as some kind of a messenger. A messenger, when it reports on the cases, on the prosecution, on the conviction, on the sentence, because it upholds both the principle of ignorance of the law is not an excuse. So it gives publicity to the prosecution that we undertake. And furthermore, it promotes deterrence. As we all know, deterrence is one of the considerations that we take when we are considering whether or not to prosecute a person or offenses. So it is so your role is very important, and we all respect the role that you play in society. And I would like to commend the Judiciary for holding this workshop. And I wish you all a fruitful deliberation this morning. Thank you.